Thank you very much for joining us today at our latest webinar on employment tribunals and COVID, what you need to know. I'm Caroline Yarrow, one of the employment partners at BDB Pitmans, and I'm joined by an absolutely stellar lineup of speakers this morning. We've got Ian Wasserman, a legal director in our team, who has significant experience of litigating cases in the Employment Tribunal, including complex cases for discrimination, detriment, and whistleblowing. Rebecca Thomas, a barrister at 42 Bedford Row, specialising in employment law. And I hope I'm not going to make you and Jude, when I come to you, blush too much, but Rebecca's been described in one of the recent legal directories as getting successful outcomes in cases that are finely balanced, always prepared, and good with witnesses. She's definitely someone that you want on your side in the tribunal. And then we have Jude Shepherd with the blue skies in Surrey, who is also a barrister at 42 Bedford Row and head of the employment team there. Jude is, and again I quote from the legal directories, able to identify the crux of a case and not afraid to take a robust approach to litigation. Again, Jude is clearly definitely someone you want on your side when looking at team tribunal. Jude has also very recently, and I understand she got her new email address yesterday, been appointed as an employment judge in the Scottish Employment Tribunal. So welcome, Judge Shepherd.
Thank you.
Just a couple of housekeeping points before I hand over to Ian to start the discussions. At the bottom of your screen, you should find two buttons, a Q&A and a chat function. If you could use the Q&A button, please, for any questions that you might have, and we'll look at the questions at the end of the three speaking slots this morning, so we can have a panel discussion on any questions that you may have. We'll try to get through as many questions as we possibly can, but if that's not possible, then we will be looking to send out a Q&A document at the end of the webinar in the coming days in any event. And if you could use the chat function if you have any technical issues. We have a wonderful colleague, Melissa, behind the scenes masterminding everything today. And if you have any technical issues, Melissa will do her very best to help you via the chat button with those. So employment tribunals and COVID, I think it's fair to say that the last 7-8 months have been incredibly challenging for employers, for claimants, and for employment law practitioners, both in terms of the number of cases, the increasing backlog, and also the way in which tribunals have had to adapt pretty quickly, actually, to dealing with employment tribunal litigation in the COVID world. I'd like now, without further ado, to hand over to Ian to start the discussions, and then we'll hear after that from Rebecca and Jude before going on to questions. Thank you very much.
Excellent. Thank you, Caroline, and a warm virtual welcome from me as well. If we just go on to the next slide, please, Melissa. I think it's probably fair to say that no one's crystal ball would have anticipated the sorts of trends that we're seeing now, and also the sorts of things that are going to come in the coming months. And as with all aspects of our lives, COVID-19 has had a marked impact on the Employment Tribunal and the sorts of claims that are being dealt with now by the Employment Tribunal and being faced by employers. And this will carry on, unfortunately, I think, for some time to come. Recent statistics on the caseload in the Employment Tribunal is fairly startling, actually, and it has revealed various trends which the government has attributed, at least partly, to the effects of COVID-19. In September, there was a reported backlog of over 40,000 cases awaiting hearing, so I'm sure Jude is going to have her work cut out for her, and that's more than the peak level that was reached in 2009, 2010 following the financial crisis. There were over 10,000 single tribunal claims that were made between April and June this year, which is the highest level since 2012. and the number of claims disposed of by the tribunals in April to June was down 31% on the equivalent period last year. So as we can see, kind of a huge pressure on the employment tribunal system at the moment. And with the number of tribunal claims continuing to grow and likely to grow in coming months, unfortunately, that doesn't look like it's going to be eased anytime soon. There's already been an upsurge in proposed redundancies, with headlines putting the figure at around 500,000 redundancies over the coming 12 months or so. The extension to the government's furlough scheme, the very recent extension during November, may help on a very temporary basis, but unfortunately, this is unlikely to prevent those inevitable job losses going forward. And as a result, I think it's fair to say that we are going to see an increase in claims from fair dismissal, unpaid wages, and in particular failure to correctly inform and consult over proposed redundancies. And that's not to mention the further tribunal litigation that is going to come directly as a result of the COVID impact in the workplace, such as health and safety claims. Hearings are regularly now being listed more than 12 months into the future, and it's not uncommon, certainly in our experience, now to be given dates in 2022. And the Law Society, in fact, is arguing that this essentially means that many people are being denied justice because of the length of time that tribunals are taking to work their way through the process. And this is, of course, a far cry from when the employment tribunals were set up in the 1960s and were designed to resolve workplace disputes fairly quickly and at minimal cost. As we all know, employment laws have expanded significantly since then. Proceedings have become a lot more complicated and run for longer. And in fact, it's probably rare now even to find a fairly straightforward unfair dismissal claim that takes less than 2 days, including remedy. But if we look now, as you'll see from the slide in front of you, in a bit more detail at the sorts of claims that we anticipate will arise out of decisions being taken by employers as a result of the pandemic. So if we start with unfair dismissal, unfortunately, the numbers of employees losing their jobs is likely to rise over the coming months, and certainly we've seen that over the last number of months. And of course, with that brings the increased risk of claims for unfair dismissal. A large number of dismissals will inevitably be due to businesses having to make redundancies. And whilst we all know that redundancy can be a fair reason for dismissal, it's going to be crucial in avoiding claims that you follow the right process. A business case, for example, is absolutely key. You don't want to be just relying on a vague explanation that it's due to the current situation, or indeed no explanation at all because you think the current situation speaks for itself. Selection and pooling is going to be very important, particularly where you have some staff who have spent periods over the last number of months on furlough and others who have not. Proper consultation and, where necessary, collective consultation, again, is going to be absolutely crucial in ensuring that you avoid those tricky claims. We also anticipate that a number of claims will be raised for detriment, having raised health and safety concerns. And certainly we're seeing those start to come through. And those, I think, are particularly important because it is automatically unfair to dismiss or to select for redundancy an employee because in circumstances of danger, which they believe to be imminent, they either refuse to work in the workplace or they're dismissed or they suffer some detriment because they take appropriate steps for self-protection or the protection of others, which may be, for example, not coming into the workplace at all. Where an employee reasonably believes that there is such danger, and it's irrelevant whether or not such danger actually existed in practice, it's that individual's reasonable belief, then you are potentially at risk of employees bringing such claims if they suffer detriment as a result of having raised those concerns. And I think this is particularly relevant in the coming times, especially as employers, hopefully over the next few months, will be starting to again encourage, or indeed in some cases try to force employees to return back to the workplace, obviously as and when we can do so. The main significance of automatic unfair dismissal is that it's not subject to the reasonableness test that you would normally have for unfair dismissal, but also crucially, there's no 2-year minimum employment requirement for claims that can be brought in the Employment Tribunal. So again, it's a potential avenue for those employees who perhaps don't have the 2-year service point to say, well, actually, I raised health and safety concerns. Next on the list is disability discrimination. Claims for disability discrimination linked to the pandemic are, I think, a real concern. Working from home, having had to shield, having to self-isolate, it's likely to increase or exacerbate certain mental health conditions, such as depression or anxiety. Imposing certain measures on staff to work from home or to travel into the office might have an adverse effect on disabled employees. Employees may live with or have caring responsibilities for disabled family members, and so may have protection against associative discrimination. And you do really need to be thinking, particularly so in these times, about the effects on disabled employees of the business decisions that you are taking. Next on the list, whistleblowing. Whistleblowing claims, in fact, have been on the rise for a while, but I think that's going to be particularly so over the coming months. 12 months or so. This clearly, as you'll know, is where employees are alleging that they've suffered a detriment having made a qualifying disclosure. And this could, for example, be because an employee has raised concerns over their employer's use of the furlough scheme, or it could be that they've raised health and safety concerns. And whistleblowing quite often is used as an alternative way in which to bring a health and safety related detriment claim. Following on from whistleblowing, and indeed not just exclusively with whistleblowing, we come to interim relief. And in certain types of unfair dismissal case, including those where the alleged reason for dismissal was because of whistleblowing, trade union activity or membership, or acting as an employee representative, a tribunal can grant an employee interim relief by making an order for the continuation of their employment pending the final determination of a case. And that's notwithstanding the fact that the employee has been dismissed by you. So the tribunal could order that effectively the employee's employment continues, and you have to continue to pay that employee until you get to a final hearing to consider whether or not the dismissal was unfair. And obviously in the current times, when that could be at least 12 months off, that can be a significant financial burden. Some of you may not have heard of interim relief applications, and indeed the majority of HR professionals will rarely receive one. But if you do, you have to act fast, and dealing with interim relief applications can be costly. Employees have just 7 days after the date of their dismissal to submit an interim relief application. And a tribunal is then required to list an interim relief hearing as soon as practicable, giving a minimum of 7 days notice. But in practice, by the time you receive the interim relief application notice in the post, quite often you will have less than 7 days to prepare for the interim relief hearing. In particular, we're seeing an increase in interim relief applications in 2 areas. First, I think there's been a lot in the press about alleged furlough fraud. Cases where, and there have been cases where employees have asserted that an employer has made false claims under the job retention scheme. In fact, at the beginning of September, the government said that around £3.5 billion paid out under the job retention scheme had either been paid out in error or in response to fraudulent claims. Employees might blow the whistle because they're aware of such claims, or because they've been told to work at the same time that they're aware that their employer is claiming relief whilst they are working. And if dismissed, having made those, or raised those concerns, or made those complaints to their employer, you are at risk, or the employer would be at risk, certainly, of an application for interim relief. Secondly, there's the potential for claims relating to breach of health and safety. Employers can argue that they allege that there was a risk to health and safety because of non-COVID secure conditions at work. And if they are dismissed as a result of raising that complaint, then again, they are at risk of a claim or an application, at least for interim relief, being made. There has been one interim interim relief claim related to the COVID pandemic, which has already come to the courts and been dealt with in the Employment Tribunal, and that was the case of Morales and Premier Fruits. And in that case, the tribunal granted interim relief to an employee who was found likely to establish that the reason for his dismissal was his trade union membership. As I've just mentioned, in limited circumstances, where an employee claims automatic unfair dismissal, the tribunal can order interim relief, preserving employment until the case is determined. And in this case, the claimant was employed by Premier Fruits, a supplier of fruit and vegetables. And as the pandemic hit in March, the claimant was asked to take a 25% pay cut and also 1 week's unpaid leave per month. In May, the claimant's trade union lodged a grievance on his behalf, alleging that the pay cut had caused him detriment and that health and safety of staff was endangered due to lack of PPE. At a subsequent internal grievance hearing, a manager was recorded showing particular hostility to the union, commenting that "I will not be dictated to by a union, and if they're not careful, they will ruin this country." And at the end of the grievance process, the claimant was dismissed for refusing to consent to the pay cut. That individual brought claims for automatic unfair dismissal and applied for interim relief. The tribunal granted his application for interim relief and made an order for reinstatement on the basis that it found that it was likely that the claimant was able to show that he was dismissed because he sought help from his trade union to bring his grievance. The tribunal relied on the recorded evidence from the internal meeting, which demonstrated clear hostility towards the union, as well as the fact that the employee in question was dismissed very shortly thereafter. The tribunal did refuse to order interim relief on the basis of the whistleblowing claim in respect of the PPE, on the basis that that was unlikely to succeed at a full tribunal. But obviously in that case, that was not particularly significant, given that interim relief had been awarded in respect of the union detriment. So this case will proceed to a full merits hearing. The employee will be entitled to receive his full pay up until that date. And I think this is likely to be the first of many cases where the tribunal has to consider an employer's response in this way to the pandemic. Now, finally, before I hand over to Rebecca, I think it's going to be obvious to all of us that some form of flexible working has now become the enforced norm for almost every business, even those that historically would have never seen them as being able to operate in such a way. Looking to the future, and as hopefully the world gets back to normal, or as much as normal will ever be, in all likelihood, many employees will be looking to retain, I would have thought, a certain degree of flexibility in their working practices. And this is likely to lead to almost all employers having to deal with at least a reasonable number of flexible working applications in the future. Whilst an employer can refuse an application if they have good business reasons, if an employer does not handle a request in a reasonable and proper manner, that employee can take them to an employment tribunal. So I think it's going to be incredibly important going forward when dealing with flexible working applications to make sure that you really focus quite carefully on any reasons if you are minded not to accept an application for flexible working, especially given the way in which businesses have been operating over the last 7 months and will certainly continue to do so over the next few months. So that, I think that probably exhausts my crystal ball, and I will hand over to Rebecca, and then I think, as Caroline has mentioned, we will take questions after we've heard from Rebecca and Jude.
Thank you, Ian. So I'm going to try and give you some information based on my practical experience of working in the tribunal system during this period. So if we could have the first slide, please, Melissa. So I'm just going to briefly touch on how the tribunal system has adapted, and Ian has given you some of the scary statistics. I think it's fair to say that some of the issues in relation to the tribunal pre-existed the pandemic, but they've certainly been compounded by it. So the immediate response of the tribunal. On the 19th of March, it was announced by the President that from Monday the 23rd of March, all in-person hearings would be converted to case management by telephone or other electronic hearings. And this was to include hearings that were already in progress. So this effectively brought the tribunal system to a halt. This was closely followed by a similar announcement in the EAT a few days later. That was the start. On the 24th of March, we received updated guidance from the President, which told us that the hearings after the 29th of June were going to remain listed for the time being, and we were given a number of review dates. I think with hindsight, that was quite an optimistic view that hearings after the 29th of June would remain listed, and people didn't really anticipate how long this situation was going to continue at that stage. Since then, the President has undertaken a number of reviews of the tribunal system, and they took place including in April and May. And that led to the beginning of June, when we were given a roadmap of how it was anticipated that the tribunal would deal with what was happening. At that stage, it was anticipated that some video hearings would take place in June, but that most hearings that were listed for June would not be affected. It was hoped that in July and August, some standard track cases, so things like unfair dismissal, would take place, and that in September and October, where we've just been, that there would be open track cases by CVP, and that there would be a small number of in-person or hybrid hearings. It was anticipated at that stage that November and December, so leading up to the end of this year, would be a period of consolidation and review. The decision to pull the cases from the tribunal was made in anticipation of the fact that the tribunal system was already overburdened at the time the pandemic hit, and it was anticipated that the tribunal would simply be unable to deal with the number of applications that would be inevitable from people trying to deal with cases in the pandemic. So that was how the tribunal sought to respond. What's the practical effect of that been for our purposes? As Ian highlighted, at the start of the pandemic in March, there were approximately 30,000 outstanding cases in the tribunal. And by June, that had risen to over 36,000. But it wasn't just the conduct of ongoing hearings and actually getting the tribunals heard that was an issue. Due to the response, there was significant issues in terms of getting any kind of correspondence from the tribunal, and including claims that were being submitted were simply sitting in the tribunal offices. This hasn't been uniform throughout the country, and it has really depended on the question of resource. So some areas have fared much better than others. And I think it's fair to say that the general perception is that the northern regions have been able to adapt and cope much better than the south and the southeast in particular. And that has been a question of resource. So, for example, the Central London Employment Tribunal, which is the biggest Southern Tribunal, at one point they had no staff, administrative staff in at all, and we were faced with the position of the judges monitoring the inbox themselves. So you can imagine how that has affected the way it's operated. Also, despite the fact that we have had this presidential guidance about how things should be conducted, I think the experience on the ground is that what has been happening in individual cases has really depended on the judge you get on the day and their willingness and ability to engage with the technology. So some judges have had a very much let's adjourn this, list another short hearing in a couple of months' time, whereas others have been much more proactive in trying to get cases heard. That has made it very difficult to predict and advise on what's going to happen in any particular case, and has also added to the uncertainty. What there has been is a shift to remote hearings. Almost immediately, case management became telephone hearings. That had started to some degree before the pandemic, but really, I think from now on will be the norm. The tribunal was also developing, or the court service, its own cloud-based platform for video hearings, sometimes referred to as Kinley, most often referred to as just CVP these days. That was a little slow to get started, and again, questions of technology and training, especially for lay members, seem to have been a particular issue of that. But we did see a shift in the summer to the first video hearings. So, for example, I did a 5-day video hearing in July, which was done entirely remotely, save for the judge who was at the tribunal. So even the lay members of the tribunal were not at the court. The other significant thing that has happened is mediations. Tribunal have been extremely keen to push mediations during this period. They have found it relatively easy to arrange those quickly, and they seem to work relatively well on the video or even telephone system. The advantage to the tribunal, of course, is that they can present a significant saving in time and resource, and they're very keen to pursue that in order to help clear this backlog. So I think the reports are that there have been quite a few successful mediations in this time, and you can expect a tribunal to be questioning you closely about whether you'd be interested in a mediation. So where are we now? We've got the CVP hearings, they're becoming much more common. Tribunals have got the tech in. Most tribunals have multiple video hearing rooms. For example, London South in the Croydon Tribunal, approximately 50% of the tribunal rooms now are equipped for all remote facilities. There are a range of types of hearings happening, and hybrid hearings are becoming very common, whereby some or all of the parties attend the tribunal and others dial in. I recently did a 4-week hearing where the claimant gave evidence and conducted the hearing entirely remotely, whereas I attended the tribunal almost every day. It was anticipated, I think, at the start that some of these longer hearings, and especially complex discrimination, would not be suitable for video hearing. But I think the reality is people are realizing that if faced with the option of having a video hearing or waiting many months or even years for an in-person hearing, people are often opting for the video hearing, even though it might not be the ideal. Nearly all case management and preliminary hearings on matters such as jurisdiction are moving to video and telephone. Can't carry on without mentioning the latest announcement this weekend on the lockdown and the effect that's likely to have on the tribunal. The message from the tribunal is business as usual, and it is not intended that the courts will close during the latest lockdown period. However, the courts, like all other areas, are dependent on the people being there to keep the tribunal up and running. And so even though it is not intended that the tribunals will close, I think the reality is that we are in the next month or so going to face significant issues with staffing, especially in those tribunals that were under the pressure in the first place, so those in the southern region. So I think we will have to prepare ourselves for more short notice adjournments. The tribunal, I think, as long as they've got the staff to keep the tribunal running, will be fairly amenable to people having to isolate or give evidence remotely, even if that wasn't initially intended. So just then moving on, next slide, please, Melissa. Just some practical matters about having virtual hearings. So as I mentioned, the technology is this cloud-based system. So for practical effect, if you go into a tribunal these days, there will be a giant screen that has a video camera attached to it that is controlled by the judge. It's very similar to Teams or Zoom, which I'm sure you are all very familiar with over the last 6 months. One thing I would say about the CVP system is this is extremely bandwidth heavy. So if you are using it, you need to ensure that you have got a good and stable internet connection. And that has been the biggest issue for people trying to use it. So should you be having a remote hearing? So is it necessary and is it appropriate? This is something we're going to have to address at the case management stage. So you will need to be ready to give instructions as to what you would like to do or your preference at that case management stage. And the things you need to be thinking about are really your witnesses. Is it safe for them to travel to the tribunal? Will they need to use public transport? Are they vulnerable? Are they isolating? Can they engage with a remote hearing? Have they got the technology either at home or can you provide it at one of your offices? The other thing you need to think about is the nature of the case itself. As I said, if it's a complex case, perhaps involving discrimination, it may not be ideal to deal with it by video. Is the claimant vulnerable? Have they got the technology to engage with the process? And sometimes people just simply don't have the tech. Talk to your employees and see if they would be comfortable, and bear in mind that you can have a mix. So you can have some people to come in person and others do it remotely. Preparation for the hearing, things that you need to think about. Remote hearings need to be prepared earlier than an in-person hearing. And the reason for that is the tribunal are now requiring documents to be sent in advance of the hearing, both electronically and hard copies. Documents that are being sent to the tribunal are being quarantined, so you can't simply hand a paper copy of a document up on the day and expect the tribunal to look at it as you did. So try to avoid those last minute documents and disclosures. My advice would be to embrace paperless. We were sort of going that way before the pandemic, but this really is the future, I think. And again, late documents or late thinking about things makes it very difficult to adapt that electronic bundle. The other thing that's very important to do is to brief and prepare your witnesses for giving evidence remotely. And there's a few things that you need to bear in mind. First of all, you'll need to ensure that your witness has a complete set of the documents and the witness statements, whether that be a hard copy or an electronic copy. If they're going to be dealing with electronic copies, you need to ensure that they've got 2 screens available to them, one to conduct the hearing and one to look at documents. Make sure that your witnesses have done a test of the connection before you go to tribunal, and there are links to tests you can do just to check that you can actually connect to the CVP, and there are troubleshooting documents available, for example, if you are having issues with bandwidth. You need to ensure that your witnesses have a suitable place to give their evidence, and that means they'll need to be in a quiet place and alone where they are undisturbed. They will still be giving evidence under oath, so it's important that if they want to give evidence swearing on the Bible, that they've got a copy or other religious book. The other thing you need to think about is the method of communication. Whereas before in tribunal, you could just speak to your witnesses, that is not possible when you are doing it remotely. Most people, I think, have found the most effective means of communication is a WhatsApp group, but you will also need to bear in mind that you will need to remove witnesses from that WhatsApp group when they're giving their evidence, so that there's no suggestion that the case is being discussed with them, and that is a very important point. Lastly, I just want to touch briefly on in-person attendance, which is still happening, but it is a very different world to that which you will have experienced before. So just a few practical points. Masks are required in tribunal. There are limits on the numbers of people who can both be in the waiting rooms and the tribunal room. So the days of bringing your witnesses for the entire case to listen to all the evidence, I think, are very much gone. And it's worth finding out the numbers allowed so you can plan your attendance accordingly. As I indicated, documents have to be quarantined, and the guidance is that each witness should either have their own set of documents or wear gloves. So again, on a practical basis, you'll need to make sure that's arranged. And another point is there are no facilities at the tribunal such as water anymore, so you'll need to ensure your witnesses are prepared. That's been a bit of a gallop through what's happening at the moment, but I'll now pass on to Jude.
Thanks, Rebecca. So I'm just going to talk to you for a few minutes about the ACAS early conciliation process and how you can make that work for you, which I think is going to be particularly important at the moment if we're seeing increased claims. And then finally, just a few minutes talking about how you can prepare for potential claims. So if you could go to the first slide, please, Melissa. So how do you make early conciliation work for you? Well, we know that with only a few exceptions, including, for example, interim relief applications that Ian mentioned a moment ago, that most claimants who are considering bringing a claim in the Employment Tribunal do indeed need to contact ACAS and effectively start the early conciliation process before they're permitted to bring a claim. Although they're obliged to notify ACAS, in fact, it's a voluntary process, so they're not obliged to then participate in conciliation. And indeed, you as an employer are not obliged to participate in the early conciliation process. Although in reality, for most claimants, they have very little to lose in doing so. And there's been some recent research done by ACAS, which they published in September this year, which makes quite interesting reading about how effective conciliation is. And that research found that only about 17% of claimants will contact ACAS and say, I have no intention of participating in conciliation, please just issue the certificate, I want to go straight to tribunal. So the vast majority of people who are considering bringing a claim against you should indeed participate in conciliation if you're willing to do so. I'm going to explain to you why the situations in which I think it would be appropriate as an employer simply to say, no, thank you very much, I'm not interested, are few and far between, without at least just having dipped your toe in the water of conciliation. My view very much is that as an employer, you have very little to lose in participating. And there's a number of reasons for that. So first of all, understanding your claimant. So conciliation is a good early opportunity to understand exactly what it is that your employee or by now ex-employee, what their grumbles are before then potentially issuing a claim. So it's an early indication of why it is they're unhappy with you and what's happened. And that allows you to take some early steps which may be very important later down the line. So it enables you to make inquiries with any relevant parties to that dispute. It means you can find out, hopefully at the earliest opportunity, if you don't already know, what might have happened and what might have gone wrong. And it also means you can preserve some evidence before memories fade or before potential evidence is lost. And it seems to me that it's particularly important in current times that you grasp this opportunity as an employer, because obviously where you've got significant redundancies or significant turnover of staff within a business, it's perfectly possible that your current or former employee who has a gripe with you and is thinking about bringing a claim may be complaining predominantly about a colleague who's also about to leave the business by way of redundancy or something else. And so you want to know that sooner rather than later. You don't want to find that out after that individual has gone, possibly also under a bit of a cloud and unhappy with the way in which their employment's terminated, so that you no longer have access to what might be important evidence to defend those claims. So essentially use the process as a bit of a fact-finding exercise to try and get to the heart of what's being complained about. Then I've said easy wins. So claimants start early conciliation for lots of reasons. It's not always because they're absolutely determined to start a tribunal claim and litigate it to the bitter end. Again, the recent research that ACAS has done is quite interesting on this. So it found that only 18% of those people surveyed said that they issued ACAS conciliation because they had to submit a claim, so simply going through the motions. 54% of them said, well, I did have to do it to issue a claim, but I was also keen to see if some kind of settlement could be reached with my employer. And 24% said they just wanted to see if a settlement could be reached and didn't have a desire to submit a claim. So, it's undoubtedly the case that you will have potential claimants who really are just testing the water and don't ever intend to issue a claim. They're just hoping to get usually a financial settlement that perhaps hasn't been forthcoming in negotiations, possibly prior to their dismissal. But the majority, certainly when they do start conciliation, at least have some intention or some belief that they may take it to tribunal. They might also have notified ACAS to strengthen their position in negotiations. So often is the view that they'll say, well, I'll start that process to show that I won't be a pushover in negotiations. The point is that for some claimants, there may be steps that you can take if they're not fully committed to litigating that are going to appease them, which might mean that that claim never happens. And that's not always a financial settlement. So there are plenty of claimants who actually want certain things, certain non-financial remedies that you as an employer may be able to swallow, either quite happily or with some compromise, which ultimately might result in a potential claim not transpiring, or indeed a claim that might at first blush appear to be quite straightforward, not then escalating into something bigger and something which may turn into expensive litigation. So, you will get those fast track cases, those fast track type cases like straightforward disputes over unpaid wages or disputes over outstanding holiday pay, low financial value claims, which you may disagree with, but may ultimately, pragmatically, at the end of the day, you may think there is merit in discussing the possibility of resolving that. Similarly, you might have a claimant who has a potential claim, but who would, for example, be happy with some sort of settlement that involved, for example, releasing them from a particular restrictive covenant in their contract, which in fact may not be a problem for you in the current context, and you're happy to release them from, which then means that they're happy to go away appeased and not to bring a claim about other matters of which they would otherwise have complained because they're moving on to pastures new. So dip your toe in that water and see what are they after. It's not always the case that claimants will come to ACAS and say, well, I won't go away unless you give me £1 million. There are easy wins to be had, and why not try and seek those out? The other merit is early merits assessments. So looking at what the potential claim may be and taking some advice about whether or not it has legs. So it's difficult to make a full assessment of merits at the very early stage of conciliation, because of course you haven't seen a pleaded claim, because the process happens before proceedings are started. So you can't look at a detailed claim and say, well, let's weigh up, you know, where we think our risks are. But you will get a decent amount of information, and you certainly will get the core of the dispute, or at least you should, from a decent conciliator, and you make sure that you ask the right questions about what it is that the claimant's complaining about. So again, it's that fact-finding exercise of saying to the conciliator, you know, what is the claimant saying about what they're unhappy about, what is the real core of this potential dispute. And that again allows you to go back and look at the matter internally. Again, if it wasn't something that was on your radar before, you can go away and talk to the relevant parties, or even if it had been on your radar, you are then able to look at what are the red flags in this situation, you know, what might have gone wrong, what might we potentially have done wrong. That allows you to take some early action. It allows you to take some legal advice if you need it, about how you might limit any damage and what risks you might be exposed to. And also, particularly in current times, it might mean that you avoid making the same mistake again. So the recent ACAS research found that 17% of employers who'd participated in conciliation had reported that ACAS had provided them with some information or advice that helped them avoid having to deal with a similar case in the future. So if you've got an employee who's challenging you on a particular process or action that you have recently taken, and you discover when looking at it that actually they might have a point, that you've not followed your own processes, or there may even be a loophole in your own processes, that may be about to be repeated many times across your business in the context, for example, of large-scale redundancies or other decisions about, for example, changing terms and conditions, all those things that we're seeing at the moment as being trends for employers. If you realise there's a difficulty through one claimant raising it, you can put it right and avoid further potential claims. So again, it's all about arming yourself with as much information as possible. And then finally, of course, you know, partly it's about setting out your position. So apparently 64% of employers who'd refused to take part in conciliation did so because they felt there was no case to answer. And I'm sure that's how many employers feel when that ACAS conciliator picks up the phone to them and says, you know, Mr. X is saying that he's going to bring a claim against you. But it's very tempting to say, well, that's complete nonsense. We just don't accept it. I'm taking a robust stance. Don't want to be seen to be showing any kind of weakness by suggesting that we might think we're in the wrong. Let's just tell him that we're not interested. But even if you know that your position's strong and actually you have no intention of entering into any kind of settlement, whether that be financial or otherwise, with the potential claimant, there's nevertheless still merit in cooperating with conciliation and being quite shrewd about how you do so. So conciliators, much like employment judges, are only human. And if one party comes to them and says and rants and rails about what they say has happened to them because they're furious about it and very emotive about it, and the other party calmly and rationally explains their position, says why they're right, shows some empathy with the other side. So it's often helpful to empathise with the claimant's position and say, we know they're upset, we're not surprised, they've lost their job in difficult times. Show that empathy and show that you can demonstrate that you viewed it from your potential claimant's perspective. But then calmly explain to the conciliator why the claim is dead in the water before it gets off the ground. That can be very valuable in setting how the dispute may then go from that point onwards. So be clear with your conciliator about what you want communicated back to the claimant. Claimants are often likely, not surprisingly, to be better influenced by what an impartial conciliator says to them about you as the employer, about your case, than they are going to be if you say it to them directly, or indeed your lawyers say it to them. if the conciliator, if you've persuaded the conciliator around, and remember they are impartial, so they're not going to argue your case, but if you pitch it right, the conciliator is going to go back and say, well, you know, what the employer said to me about their case is this. That can be very persuasive, and it can be enough to prompt a claimant not to go and start that dispute, so not to issue the tribunal claim. And actually, of employee participants in the recent survey that said they decided ultimately not to go to tribunal, they said 2/3 of them said that ACAS was a factor in that decision not to proceed, at least to some extent. And it's within your gift to influence that. So it's a very valuable process. Don't dismiss it out of hand. Because simply refusing to engage with them when they're already cross about something that they think they've done, that you've done to them, that may well prompt them just simply to say, well, let's give it a crack and start the claim and see what happens. And before you know it, you're bowling headlong towards a tribunal hearing, you know, that's going to happen way off in the future, and the costs, the attendant costs involved in that. So although only about 1/4 of cases that go to conciliation in fact result in a settlement, there are lots of other reasons not to reject it out of hand at the outset. So that brings me on to my next slide, Melissa, if you wouldn't mind skipping ahead. So this, if you don't manage to put off your claimant and you are facing a tribunal claim, this is just a couple of tips about being prepared. So there's nothing specific in the COVID world that's any different to before about how you ought to prepare for the potential of a claim. But given the potential upturn in claims, you know, your preparation is likely to be more important than ever. You know, so take a leaf out of the Boy Scouts book, always be prepared, always be thinking one step ahead to be prepared to deal with any challenges you might receive to actions taken. So if you're having to make difficult decisions, which most of you are at the moment, try and sense check all of those key decisions and think about how an impartial onlooker might think about it. So try and put your employment judge's hat on. You know, if I look at this in the cold light of day, how is this going to be viewed by an employment tribunal? You know, and if in doubt, seek legal advice and ask your lawyers to put their employment judge's hats on and say, you know, actually, you know, perhaps think about doing this differently, or think about doing it in this way, or expressing it in this way. Instilling good practice in your managers. You can't anticipate every situation, but you know, instilling in your people managers the basic good practices of keeping good notes of meetings, following meetings up with summary emails, at the same time being cautious about what they say in their emails, which leads me on to my next heading, creating the right paper trails. So, you know, Rebecca and I, long in the tooth in the tribunal, have seen many a case won or lost on the strength of contemporaneous documentation. So good, measured, detailed documentation is an absolute godsend for your witness. It gives them a crutch to hang on to. It's a godsend for your representatives because it gives them something tangible to deal with, and it's good fodder for cross-examination of the other side. And it's great for your tribunal. It gives them something to hang that proverbial hat on. But similarly, though, managers who tend to shoot from the hip, who fire off missives in emails without thinking about them, who do things without sense checking them, you know, are great fodder for the other side and great fodder for cross-examination. They will be hoisted by their own petard by things they've said in emails. We all know that tone and context don't always come across in emails, and it will catch people out under cross-examination. So just be cautious about what is being documented. Don't be shy about documenting things because it's really important, but sense check it before you do. And a plea to all of you out there sort of dealing with HR matters, sort of not to record absolutely everything, every brain dump a manager might give to you in an HR context. So again, you know, I'm sure that Becky's got as many stories as I have about the cringe moments you get when you read those really comprehensive HR notes of the discussions between the HR manager and the manager who's dealing with a dismissal, say, you know, where they record absolutely everything and say, the manager's absolutely insistent they're going to dismiss Mr. X, and I've told him quite robustly he has absolutely no fair grounds to do so. You know, that obviously those exchanges will happen and do happen in a commercial context. You know, but you don't have to record absolutely everything. People will play devil's advocate. They will sense check things. that context might not come across later in tribunal. So try and just be careful, particularly from an HR context, about what you are recording and what you are creating so far as a paper trail is concerned. That's a whiz through two fairly large topics. So I think we're now going to open it up to any questions.
Some questions, yeah. So we've got a few come through, and I appreciate we've probably got about 2 or 3 minutes, but obviously we're happy to stay on if the participants want to stay on as well. I mean, I want one sort of final point, picking up from what you've just said, Jude, actually, and in terms of paper trails and preserving evidence, I think we probably all need to bear in mind it's more difficult to do that in a virtual world. So, you know, the notebook is not on the desk of the manager in the office, it's in someone's home. So don't just think I've finished with that notebook and put it somewhere never to see the light of day again. And I suppose the other thing that I've seen as well is people communicating in a different way. So WhatsApp text messages, there's a higher prevalence of that. So actually, you know, if there are messages being sent in those particular, using those particular means and media, you know, preserving those. So lots to think about. But in terms of questions, so if a spurious threat, this is from Stephen, if a spurious threat of dismissal for a potential protected disclosure is made and is withdrawn throughout the negotiated exit process, how do you word that in the settlement agreement? Ian, do you want to perhaps take that one?
I think, well, it's obviously it's positive in a sense if you are at the stage where you are agreeing the wording of a settlement agreement. From the employer's perspective, even in a settlement agreement on a without prejudice basis, you're not going to be admitting liability. You will want to make sure from the employer's perspective in the settlement agreement that absolutely all of the potential claims the individual will have, so in particular claims for unfair dismissal, automatic unfair dismissal, whistleblowing detriment, are properly settled and compromised by the wording of that settlement agreement. And again, I mean, you just don't want to put yourself in a position where though you're making any admissions, even in kind of without prejudice settlement discussions or in the settlement agreement regarding kind of potential protected disclosures being the reason for dismissal or anything of that nature. But again, I don't think you would generally go into too much detail in terms of the nature of the allegations or what's gone on in the settlement agreement. You just really need to make sure that the right claims are properly settled by the agreement that's being signed.
Thank you, Ian. Again from Stephen, and this is a really good question. If an employee says that they're going to apply for interim relief, what advice would you give to the employer to prepare for this, given the short timescales you mentioned? I mean, I think if you've got any sort of advance notice that that's where the employee is going, that is absolutely fantastic, because quite often the first you'll hear of it is when the claim lands. I suppose on that, and I'll hand over perhaps for Rebecca's thoughts in a moment, there's a practical issue in there to my mind, that these papers will be served by post. And once they've been served by post and you've got them, you've got to turn things around incredibly quickly. So I suppose from a purely practical level, making sure that actually, particularly as we go into a second period of lockdown, making sure you have someone who is checking the post and picking up the post. It sounds a simple thing, but in terms of sort of wider steps to prepare, Rebecca, have you got any thoughts on that?
Yes, well, I suppose the one thing I would say is, and I might also just refer to Jude, because I know she's very recently done an interim relief application. One thing to bear in mind is that unless directed otherwise, at an interim relief hearing, there's no oral evidence given. So the tribunal are really looking at the documents. So what you want to be focusing on to defend an interim relief application is to be able to show the tribunal from the documentary evidence that the claimant is unlikely to succeed. So, for example, very clearly, if it's a dismissal, which it will be, very clearly documenting the reasons for the dismissal and showing that they're not for the protected reason. If it's a whistleblowing basis for an interim relief claim, have a good look you know, are some of the things they're complaining about predating the disclosures they're relying on? Make those practical points. I agree what you say, Caroline, about checking your post. It's very important. I think I have to sound a word of warning. Because of the pressure of tribunal, however, some interim relief applications are not coming on as quickly as they should be. I dealt with one at the end of last year that was a year old. That's an extreme example, but of course the practical effect for the employer is you're potentially paying a very large wage bill for a long time. So it is important to try and head it off at the pass if you can. I don't know if you want to add to that, Jude.
Yeah, I mean, COVID is definitely delaying these things. So although the claimant has to put in the claim within 7 days, you know, they're not getting on for hearing. I had one that was done during COVID and only came up for hearing in August. So, you know, not as long as that, but they are being delayed. So, and in reality, you know, often an employee will not tip you off that they're applying. The first you will hear of it is from the tribunal. And so it takes ages for them to process it. And then, of course, they say, I've had an interim relief application, there's a hearing next week. And you go, so the top tip is, I mean, if you are tipped off, fantastic. Get, as Becky says, get your documents in order. Literally pretend that you've got a trial coming up within 7 days and prepare for it as you would like that. Get your disclosure, get your documentation in place. The other thing that I find is crucially important, although no oral evidence is taken, you can produce draft witness statements. So the best way to win an interim relief application, in my experience, is to immediately go to your key witnesses, draft statements for them as though they were giving evidence at the trial, so that you can put those in front of the judge and say, it's not the case that we dismiss this person because they blew the whistle. We dismiss them because of this gross misconduct. Here's what happened. Here's the chronology. Because again, a judge, it's a very summary process. It's a very fast process. They're looking at, you know, is the claimant likely to succeed? Ultimately, you need to throw everything you possibly can at it at the earliest possible stage. So, you know, prepare, get your documents ready, get your witness evidence ready, and throw everything you can at it, because otherwise it's going to be very expensive.
Thank you very much. Very, very helpful tips. Question from Michael. I have 2 potential hearings which are going to require interpreters. How will that work in the future? Rebecca, Jude, any thoughts? Have you had any cases during COVID with interpreters?
I haven't. I know that somebody in the team has got one, and that sort of view generally has been that there are attempts to sort of do in-person hearings where you've got interpreters because of that difficulty with remote hearings. So I think you will find that most tribunals, where they're able to, will try and accommodate such cases in person, or at least from a hybrid perspective. I mean, I suppose creatively what you might have to do is to say, you know, if we're just not going to get an in-person hearing, how can we bring it about so that at least the interpreter and the party who needs the interpreter are in the same room, because, you know, it's very difficult otherwise. But I think tribunals do sense a bit of nervousness about doing those by remote hearing, you know, completely understandably. But in the current situation, we're just going to have to try and make those things work.
So some kind of hybrid might work best there, with the claimant and interpreter and representative. They've got one, you know, together in the tribunal with everybody else, perhaps doing it by CVP. I think we've got one final question from Angie, if we've got time to deal with it. And I'm going to put this to you, Ian, if that's all right. We're using a combination of remote and in-person hearings for disciplinary and sickness interviews. Do we need to amend our procedures to reflect this? Great question.
I mean, I think, as we all know, procedures are very important, and it's what guides managers, it's what employees will ultimately look to see whether or not you're doing what you're meant to be doing. The reality, however, at the moment is that many policies and procedures won't have anticipated the situation that we're in. And to the extent that policies and procedures don't provide for remote hearings, telephone hearings, things of that nature, I think in an ideal world, if policies and procedures can be updated to reflect that, then great. Otherwise, just ensure that when you're communicating with staff either who are off sick and you need to engage with or who you have to call to disciplinary hearings, just make sure that in the invitation letters or the correspondence with those individuals, you make it very clear that this is how we are going to deal with these procedures in the current times, given that people can't be coming into the office, we can't be having in-person hearings. And I think as long as everyone is on the same page and it's made very clear to everyone, and of course you're taking, particularly where someone is off sick, you're taking account of adjustments that might be needed to a process, then I think you're going to put yourself in a good position. And of course, in slower time, if necessary, when things calm down, perhaps, I think lots of employers will be looking to update policies and procedures just to reflect the fact that we do now all live and operate in a different world, and meetings that we never would have undertaken without being in the same room previously now kind of quite easily and efficiently can be undertaken. So I mean, yes, I think policies ultimately should be updated to reflect any change of practices that will be relied upon. But I think as long as you're making it clear in individual cases how you're going to be dealing with processes, that will put you in a good position.
Thank you, Ian. So I think that's all of the questions. So thank you very much to all of you that have raised those. Thank you very much, obviously, to our brilliant panel, Ian, Rebecca and Jude. It's been really insightful and interesting. I am sorry to all of you that we've kept you slightly later than 10 o'clock, but I do hope you found it useful. And I think I'd just like to say a final thank you to Melissa, who's done an absolutely brilliant job behind the scenes and has made this morning possible. So thank you, Melissa. I hope you all have a brilliant day. And we'll be sending details about the next webinar in due course. Thank you very much.